Supreme Court poised to end constitutional revolution that's marred U.S. governance for 40 years, which may result in the end of our government as we know it, and that's a good thing. The Supreme Court has boxed itself in by running away from making decisions concerning the Constitution and the rule of law. Refusal of the court to take on these many issues has led them to this judicial dead end. This ruling could very well put an end to the 438 agencies and bureaucracies infesting our federal government. It could mandate that the 435 representatives take complete operational control of the bureaucracy, as the Constitution demands. And just by the numbers, it would be impossible. But there is a solution. A prior case, 117 CV 1793 and Appeal 195028, brought by 5 guys from New Jersey. It was strung along for 4 years and finally dismissed as not justiciable by the courts. In the ensuing years, the federal courts have ruled decisively that the questions that we raised are justiciable and have paved the way for the ERA to be the 28th Amendment. In addition, the federal courts have ruled that ratification of an amendment occurs the moment the requisite number of states' legislatures approve the amendment, and neither the Congress or any other part of the government has any say in the matter. Now that the federal courts have reaffirmed what the Constitution instructs on amending itself, we have the solution and the proof of ratification. Article the 1st was the first of 12 amendments proposed to be added to the Constitution. In simple terms, it mandates one representative for no more than 50,000 citizens. In today's figures, that would mean about 6,500 representatives. And that's the solution to this problem. They could no longer delegate their authority to unelected and unaccountable employees. They would be responsible to the voters. It was ratified by 1792. The proof is in the book. Supreme Court poised to end constitutional revolution that's marred United States governance for 40 years. By Thomas M. Boyd, published Jan 14, 2024, 3:20 p.m. Eastern by New York Post. When Justice John Paul Stevens issued his 1984 opinion in Chevron USA v. National Resources Defense Council, he started what legal scholar Gary Lawson later called nothing less than a bloodless constitutional revolution. At long last, on Wednesday, the Supreme Court will hear 2 cases that may signal the beginning of the end to that revolution. Article 1 of the Constitution explicitly directs that all legislative power herein granted shall be vested in a Congress of the United States, not regulatory agencies. Yet Justice Stevens' opinion found that agencies may properly rely upon the incumbent administration's views of wise policy in reasonably defining statutory ambiguities. The legal doctrine that Chevron spawned became known as Chevron Deference, and former President Ronald Reagan's White House counsel, Peter Wallison, pointed to it as the single most important reason the administrative state has continued to grow out of control. 40 years of regulatory and judicial tumult has ensued, finally crescendoing to a point that has compelled the Supreme Court to intervene. Loper Bright Enterprises v. Raimondo from the District of Columbia Circuit and Relentless v. Department of Commerce from the First Circuit are now before the court. The Supreme Court may end a trend set by Justice John Paul Stevens in 1984. Eric Kane, Zuma Presswire, SplashNews.com. Both are companies that fish for herring in New England and are family-owned and operated. And both are subject to the Magnuson-Stevens Act, which governs fishery management in federal waters. The act allowed the National Marine Fisheries Service to require herring boats, relatively small vessels that normally carry only 5 to 6 people, to also carry federal monitors to enforce its regulations. As a next step, however, and without any express statutory authorization, the NMFS decided to require Loper Bright and Relentless to also pay the salaries of these monitors, estimated by the NMFS to be $710 per day, an amount that can exceed the profits from a day's fishing. Both circuits validated this rule by pronouncing statutory silence to be an ambiguity that required Chevron deference. When it accepted certiorari in both cases, the court posed a 2-part question for the litigants to address: whether the court should overrule Chevron or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. These 2 options reflect the thoughts some of the justices have evidenced in their prior opinions. For example, in his majority opinion in West Virginia v. EPA, Chief Justice John Roberts commented, "We presume that Congress intends to make major policy decisions itself, not leave those decisions to agencies," citing U.S. Telecom Assen v. FCC. And in his dissent in City of Arlington, Texas, v. FCC, joined by Justice Samuel Alito, he wrote that the question of when an agency enjoys interpretative authority must be decided by a court without deference to an agency. In their concurring opinion in West Virginia, Justice Neil Gorsuch, joined by Justice Alito, referred to the explosive growth of the administrative state since 1970, as well as former President Barack Obama's 2014 promise to use executive orders and administrative rules to bypass Congress. He wrote, "The Constitution does not authorize agencies to use pen and phone regulations as substitutes for laws passed by the people's representatives." Similarly, Justice Clarence Thomas, in his 2015 concurring opinion in Michigan v. EPA, asserted that the judicial power requires a court to exercise its independent judgment in interpreting and expounding upon the laws, adding that Chevron deference precludes judges from exercising that judgment. The two cases are Loper Bright Enterprises v. Raimondo and Relentless v. Department of Commerce. Interest in this case has been immense, with more than 65 amicus briefs filed with the court by a wide range of interested parties. Somehow it might be fitting for this court's ruling on the future of Chevron's deference to also be rendered on June 25th, 40 years to the day after it was created. When a decision will be forthcoming is unclear, but Chevron was originally released on June 25, 1984, days from the end of that year's term. A ruling striking down that overly broad grant of power to federal agencies is long overdue. Thomas M. Boyd is a former U.S. Assistant Attorney General, appointed by President Ronald Reagan.